Welcome. My name is Zachary Cook. I'm a law student at the Indiana University Maurer School of Law. This video is part of a three-part series designed for attorneys and prisoners who file lawsuits without the assistance of a lawyer. This first installment will focus on the Prison Litigation Reform Act. The second installment will discuss the two elements of deliberate indifference. And while this video will shed some light on the exhaustion of administrative remedies requirement, there will be more details about that in the third installment. Let's start with a little background. When a prisoner's rights are violated, he or she may choose to address the violation by getting the courts involved. A state prisoner can file a lawsuit under 42 U.S.C. section 1983, and a federal inmate can file a lawsuit based on Bivens. In 1996, the Prison Litigation Reform Act, or PLRA, was enacted. This federal law was passed in response to the increase of prisoner litigation in the federal courts, and was designed to decrease the amount of prisoner litigation within the court system. Essentially, the PLRA adds additional requirements for prisoners filing lawsuits, and it places limitations on a prisoner's recovery and the attorney's fees available. I will be discussing three of the PLRA's requirements. First, I want to discuss the prisoner's obligation to exhaust administrative remedies before filing a lawsuit. Next, I will cover filing fee and screening requirements. Lastly, I will go over limitations on recovery. Let's start by outlining the elements necessary for a claim to be subject to the PLRA. The PLRA applies to all lawsuits brought by prisoners with respect to prison conditions. Examples of prison conditions include inadequate medical care and food, denial of religious services, excessive force, and failure to protect. The term prisoner means any person incarcerated or detained in any jail, prison, or other correctional facility. The phrase lawsuits brought by prisoners means that a prisoner who has been released is not precluded by the PLRA from filing a lawsuit for incidents concerning prison conditions which occurred prior to his release. Whether the PLRA applies depends on the plaintiff's status as a prisoner at the time the lawsuit is filed, not at the time of the underlying incident. The PLRA requires that an individual exhaust all administrative remedies that are available prior to filing a lawsuit. Let's unpack the exhaustion of administrative remedies requirement a bit. In order for a prisoner to meet the exhaustion of administrative remedies requirement, he or she must take all possible steps as required by the prison's grievance system. When I say possible steps, I mean a prisoner is only required to exhaust available remedies. So he or she is not required to exhaust any remedies that are not available. With that in mind, and because exhaustion of administrative remedies is an affirmative defense, it is a defendant's burden to prove that an administrative remedy was available to the individual bringing the claim. Exhausting administrative remedies will also require proper exhaustion. In other words, not only must an individual take any and every step necessary to follow the prison's grievance system, he or she must do so the right way. Please keep in mind, doing it the right way includes complying with all filing deadlines and any other procedural rules. And beware, those can be tricky. For more on exhaustion of administrative remedies, please stay tuned for part 3 of this three-part series. Next, let's discuss a prisoner's obligation to pay a filing fee. 28 United States Code section 1915 governs proceedings in forma pauperis. This Latin phrase, in forma pauperis, simply means in the form of a pauper, and refers to a plaintiff who has his filing fees waived after declaring his inability to pay. This statute reads, "In no event shall a prisoner be prohibited from bringing a civil action or appealing a civil or criminal judgment for the reason that the prisoner has no assets and no means by which to pay the initial partial filing fee." In other words, just because you can't pay your filing fees initially doesn't mean that you cannot move forward with filing your claim. But, while the statute allows an alternative to paying filing fees up front, it does not mean the prisoner receives a windfall. The prisoner is still required to pay the full filing fee. He or she just doesn't have to pay it up front. The court must assess, and when funds exist, collect partial payment of the filing fee until the filing fees are paid. Now, we will discuss screening and the 3 strikes provision. Let's start with screening. As stated by 28 U.S.C. section 1915 cap A, The court shall review, before docketing if feasible or as soon as practicable after docketing, a complaint in a civil action in which a prisoner seeks redress from a governmental entity or officer or employee of a governmental entity. In other words, the court is responsible for reviewing a complaint where an individual seeks redress from a governmental entity or officer or employee as soon as possible. As stated by 28 U.S.C. Section 1915 Cap A, B, on review, the court shall identify cognizable claims or dismiss the complaint or any portion of the complaint if the complaint is frivolous, malicious, or fails to state a claim upon which relief can be granted, or seeks monetary relief from a defendant who is immune from such relief. In other words, there are two circumstances where the court should not allow a complaint to move past the screening process. The first is if the complaint is frivolous, in that it does not have any serious purpose or meaning, malicious, in that it is intended to just cause harm, or does not state a claim that can be redressed by the court. Whether or not a complaint fails to state a claim upon which relief may be granted is governed by the same standard as a motion to dismiss under Rule 12 of the Federal Rules of Civil Procedure. The Supreme Court has explained that to survive dismissal, the complaint must contain sufficient factual matter, accepted as true, to state a claim for relief that is plausible on its face. A claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The other circumstance where the court should not allow a complaint to move past the screening process is when it seeks a money reward from someone who is immune from monetary relief. Some defendants who may be immune from suit include judges who have judicial immunity, prosecutors who have prosecutorial immunity, and states that have sovereign immunity. Now that we know about the screening process, let's discuss the three strikes provision. We all know about the three-strike rule in baseball, right? Well, Section 1915G prohibits a prisoner from proceeding in forma pauperis, or without the prepayment of the full filing fee, if they have 3 strikes. Let's start by clarifying exactly what a strike is first. A prisoner incurs a strike when their case is dismissed based on the screening requirement. Hence, the case was frivolous, malicious, failed to state a claim for relief, or demanded monetary relief from a defendant with immunity. If the prisoner has 3 or more cases or appeals that were dismissed because they were frivolous, malicious, or failed to state a claim upon which relief may be granted, that prisoner is required to pay the full filing fee, and if they fail to do so, their case will be dismissed. There is, however, an exception to this rule. This is the imminent danger exception. This exception says that if a prisoner is under imminent danger of serious physical injury, he or she may bring an action and proceed without prepayment of the filing fee, despite the fact that the prisoner may already have struck out. Now, let's move on to the limitations the PLRA places on recovery. The PLRA does not just add extra steps an inmate must complete before filing a suit. The PLRA also places limitations on the recovery available to a prevailing plaintiff. Let's take a look at how the PLRA affects remedies. Let's start by discussing monetary damages. Section 1997E states that an incarcerated individual may not bring a federal civil action for a mental or emotional injury suffered while in custody if he or she cannot show prior physical injury or the commission of a sexual act. For example, if an inmate is denied access to written materials in violation of his First Amendment rights, he cannot claim compensatory damages for the mental distress he suffered by the denial, because the alleged violation does not include a physical injury. Now, let's discuss injunctions. Title 18, United States Code Section 3626, states that courts may not grant or approve any prospective relief unless the court finds that such relief is narrowly drawn, extends no further than necessary to correct the violation of the federal right, and is the least intrusive means necessary to correct the violation of the federal right. The court shall give substantial weight to any adverse impact on public safety or the operation of a criminal justice system caused by the relief. Injunctions do not require a showing of physical injury, so a prisoner can seek an injunction without being able to show a prior physical injury. Now, let's move on to attorney fees. Similar to injunctions, there is no physical injury requirement. The PLRA limits the amount of attorney's fees that an attorney may recover when representing a prisoner. Section 1997(e)(d) also places limits on the hourly rate that can be sought, unless a prisoner enters into an agreement to pay out of his or her own pocket the enhanced fee. Finally, a portion of the plaintiff's judgment shall be applied to satisfy the attorney's fees awarded against the defendant. Let's discuss a Supreme Court case that shows how the PLRA can affect attorney fees. Let's talk a little about the Supreme Court case Murphy v. Smith. In Murphy v. Smith, a prisoner by the name of Charles Murphy brought an action against two prison guards under Section 1983 and state law, alleging that the officers hit him and in the process fractured part of his eye socket and then left him without medical attention. This case established that, as required by the PLRA, the money for an individual's attorney's fees will come from that individual's damages award first. Furthermore, the defendant will only be responsible for the balance if and only if 25% of the individual's award is not enough to compensate their lawyer fully. So, district courts are to apply as much of the judgment necessary, but only up to 25%, in order to satisfy an award of attorney's fees. The court reasoned that the specific statutory language of the statute supports the Seventh Circuit's interpretation for multiple reasons. The first reason is because of the mandatory phrase, "shall be applied." This phrase suggests that the district court has some non-discretionary duty. In other words, the court does not have the option to choose whether or not they perform. The second reason is because the "to satisfy the amount of attorney's fees awarded" phrase tells the purpose or aim of the "shall be applied" duty. Lastly, to satisfy an obligation, particularly a financial obligation, usually involves discharging the obligation in full. Altogether, the three reasons suggested that the district court must act with the purpose of fully discharging the fee award. Furthermore, the district court must use as much of the judgment as necessary, but not exceeding 25%. To summarize our points today, the PLRA applies to prisoners complaining about prison conditions. The PLRA requires exhaustion of available administrative remedies. Filing fees don't always need to be paid up front. Complaints that are malicious, frivolous, fail to state a claim, or seek money from immune defendants receive a strike at screening. After 3 strikes, the prisoner must pay the full filing fee up front. Physical injury is required for monetary damages. However, no physical injury is required for injunctions or attorney's fees. Murphy v. Smith holds that the defendant only pays attorney's fees if 25% of the award can't cover the fees. Now that you have a better understanding of the PLRA, we'll be wrapping up this video. Thank you for watching. I hope that it gives you a better understanding of the PLRA. Please stay tuned for parts 2 and 3 of this 3-part series.